Hi everybody, welcome to the 12th lesson for Legal Studies 3-4. In today's video, we're going to be looking at the relationship between courts and parliament, the reasons for law reform, and the role of the individuals, court and media in influencing the need for law reform. To start off with, we're going to focus on the relationship between courts and parliament. And as we've looked at throughout the past content, it's very clear that courts and parliament are interrelated as they both operate, as separate branches of government, but administer, essential political and legal functions. One of the ways in which parliament and the courts are related is through the supremacy of parliament. So parliament is the main lawmaking body in Australia. And so when we talk about the ability of courts and both parliament to make law, courts through the common law principles of precedent and statutory interpretation, and parliament through acts of parliament and statutes, the laws made by parliament are of a higher authority. And so courts can effectively be undermined by parliament. And that's what we call the supremacy of parliament. So parliament is the main lawmaking body in Australia, and it has very wide jurisdiction to make laws in any area as long as it adheres to the separation of powers, judicial powers, and the sections of the Constitution which give it power. As parliament is the main lawmaking body in Australia, it actually establishes the courts, and it establishes each court's jurisdiction to hear matters arising under certain issues. And in doing so, parliament also creates the sentencing guidelines for courts. So remember, in criminal law, when judges are deciding an appropriate sanction for an offender, they will look to a range of sanctions and decide where on the scale that fits. For example, the sentencing guideline for murder may be 6 months to life. And so those guidelines are created by Parliament, and then the courts use them to decide what an appropriate sanction is for that specific case. So the supremacy of Parliament means that courts and parliaments are interrelated in that way. Related, but in the textbook and in the course, they talk about them separately. Under the supremacy of Parliament comes the codification and abrogation of precedents. Starting with codification, codification is where Parliament passes legislation which confirms a previous common law principle created through judge's precedent or statutory interpretation. An example is Mabo, where the High Court confirmed the native title rights of Indigenous people, and Parliament subsequently passed the Native Title Act to reaffirm and codify what the judges had said in that case. The opposite of that is abrogation, and that's where Parliament can pass legislation to cancel and override a common law principle created by judges. So this was an example of this was in the case of Trigwell, where the court used an old English precedent which said that landowners don't have a duty of care to keep their animals on their property, and they're not responsible if their animals get off the property and cause an accident. In response, Parliament cancelled that principle, and they passed the Wrongs Act, which stated the opposite, that all landowners have a duty of care to keep their animals on their property. So through the supremacy of Parliament, Parliament is essentially able to confirm or override and cancel a common law principle made by courts. So because Parliament is the main lawmaking body, they have ultimate authority to make law and can ultimately undermine courts if they wish to. Another way in which courts and Parliament are interrelated is through statutory interpretation. Parliament creates the statutes and acts, and then the courts interpret the meaning of those acts and can narrow or broaden that application of the act. Similarly, the High Court interprets the Constitution, and as we learned from the last area study, that may mean that the Parliament's powers actually change, because the High Court may interpret the Constitution in a way which gives more powers to the Commonwealth at the expense of the states, or vice versa, however that is more rare. The final way in which courts and parliaments are interrelated is through the court's ability to influence parliament. And we learned about this in the last video through disapproving precedents. So this is where a lower court is bound by a precedent and they cannot do anything to change it. However, they express their dissatisfaction for that precedent and hope that Parliament will abrogate and override that principle in the future. So that's one way in which the courts can influence Parliament. Another way in which courts can influence Parliament is through an unjust court decision, use of an outdated precedent, or public outrage in response to a court decision, which will force Parliament to change the law on that issue because they can identify that the views of the majority do not support that law made by judges. And therefore, in order to be representative, Parliament has to override that principle. Now we move on to the reasons for law reform. So laws intend to protect our society. And so in order for laws to be effective, they must be known to society. They must be easily understood to all people, regardless if they have a background in the law or not. They must be able to be changed through mechanisms such as Section 128. They have to be acceptable to society, so reflecting our views and values and opinions on certain issues. And they also have to be enforceable through courts. One reason for the need for law reform is changes in societal attitudes. So something that maybe previously had been banned is now tolerated in society, or something that was previously tolerated is now previously accepted is no longer tolerated by society. So, for example, smoking in public, there were laws about, previously there was very little laws about smoking. However, now as people are becoming less tolerant and understand the health effects of smoking, there are regulations on where you can and can't smoke in public and private areas. Another example of that is plastic bags. So society, used to use plastic a lot more freely without really understanding the risks on the environment. And now, as we're more aware of the risks of climate change and plastic and rubbish and pollution, that kind of thing, there are more laws in place to reduce our plastic use and encouraging businesses to switch to recyclable and renewable alternatives. Another reason for the need for law reform is a change in societal conditions and social conditions. So if there has been an increase in a certain type of crime, then Parliament will need to make laws on that specific issue. So for example, a couple of years ago, there was an increase in one-punch accidents. And so Parliament had to make laws in response and become more strict on those types of crimes. Another need for law reform is advancements in technology. So as new methods of technology are formed, we need laws to regulate the use of those technologies. So for example, clones and gender reassignments are two things that recently Parliament has had to make laws on just because they are becoming more prevalent. Next is the need for greater protection of the community. So again, kind of similar to the societal conditions, but more so because it's just a threat to society. And there's fear among the community for certain issues. So for example, terrorism or bail laws, great need for stricter bail laws in response to, accidents and situations like Jemima, where individuals on bail commit very serious crimes. And finally, the final reason for law reform is improved access to the law. So needing to provide individuals who would not have otherwise had access to courts, providing them with interpreters, and overcoming cultural barriers through expansion of the Koori Court. Now we're going to look at how individuals can influence the need for law reform through informal political pressures. So informal pressures come from individuals outside of the lawmaking process. So from members of the community and businesses and that kind of thing. So a petition is one way in which individuals can influence law reform. And a petition is just a written proposal for legal change, which is accompanied by signatures. And the extent of the signatures indicates the extent of the support. Petitions have become more and more prevalent due to the use of electronic petitions and change.org and those kinds of websites where you can gain support very quickly. And that's why petitions are very effective at influencing law reform, because they're very inexpensive and simple to gain support, especially through electronic petitions. Petitions are also effective as they increase public awareness for issues. So even if you, even if you don't gain a significant amount of signatures, by sharing something, a petition and change.org website, your followers then can read up on the issue and you can gain support and momentum for your issue very quickly. However, the main issue with petitions is that Parliament receives thousands per year, so they may be overlooked. And an example that you can look at is the Oscars law petition, which led to the banning of puppy mills in Victoria. Another way in which individuals can influence law reform is through demonstrations. So demonstrations are where a group of people gather to express their collective dissatisfaction with the law. And demonstrations are very effective in raising awareness, and they can attract free media attention very easily. It's similar to petitions through Facebook and online platforms. It's very easy to gain awareness for the demonstration, to increase attendance, which therefore increases the effectiveness of the demonstration. And also it can raise awareness for the specific issue that is being protested. However, demonstrations may attract negative media attention, which reduces their credibility and therefore the likelihood of Parliament to actually respond. And especially in instances where the demonstration would cause public inconvenience. So an example of that is the 2017 taxi protest, where 200 taxi drivers drove really, really slowly over the Balti Bridge and into the city to protest the lack of regulations on Uber. And because of the traffic it caused during peak hour and delays, the protest was not looked upon very favourably. The next way that individuals can influence a change in the law is through courts, and this is all kind of stuff we've talked about already. So as we've learnt already, individuals can raise awareness for the need for law reform by initiating a claim in court. And so courts are there for individuals to challenge the validity of laws and the actions of government or Parliament. If the court believes that something has been done unconstitutionally or unjustly, then they can declare legislation invalid, or in the case of the Constitution, ultra vires. Court is a very effective way of influencing a change in the law because it gains significant media attention if it's on a very large controversial issue. Another strength of courts is that the judges are independent, and so they're not affected by political grounds and considerations and are willing to criticise government and Parliament. However, as we've learned, there are significant costs involved and delays involved in initiating a claim in court. Also, the fact that individuals have to have standings, they have to be directly affected by that issue. They can't just bring a claim on the common good of society, even if something is seen as unfair. And also the fact that judges have to wait for a case to be brought before them, and they are limited to the specific issues of the case. So judges have a limited scope to remedy issues in the law. And an example is the Norrie case, which is where an individual challenged the New South Wales law about recording birth certificates in a gender-neutral way. And the High Court ruled that it was invalid for New South Wales to prevent an individual from having a gender-neutral birth certificate. And that actually influenced Victoria to change their laws. So Victoria now allows gender-neutral birth certificates. And so that's how not only did that individual bringing the claim change the law in New South Wales, it also raised awareness for that issue and led to other states implementing the same changes. And finally, individuals can use the media to influence a change in the law. So when we talk about the media, we are talking about both traditional media through newspapers, TV, radio, and also social media. The media is essential at educating people about issues and injustices in the law, and it's extremely effective at generating widespread support and encouraging debate for issues in the law. It also allows politicians to outline their political stance and respond to issues through debates and forums. As social media has a global audience, it attracts significant media attention. And also, social media platforms can be used by individuals to directly engage with politicians. So, you can comment on Dan Andrews' Facebook page if you were wanting to. Also, it can be used by politicians to gauge the views of the majority and ensure that the laws that they're reflecting, that the laws that they pass reflect the views of the majority. However, the issue with the media is that often the information portrayed online is overly simplistic or maybe from an inaccurate source, which doesn't actually accurately portray the issue at hand. An example of the media influencing a need for law reform is the ABC Four Corners report into the abuse of youth in detention, which then led to a Royal Commission inquiry. So that brings us to the end of that video, and I hope to see you in the next one.